Welcome. The first case is number 47.
Ready for court, please?
Counsel, do you want any rebuttal time?
Yes, Your Honor. 8 minutes, please.
8 minutes. Okay. 8 out of your 18.
Correct.
You've got it.
Thank you.
Go ahead.
May it please the Court, I'm Susan Summer, appearing on behalf of appellant DebraH. This case cries out for application of traditional equitable estoppel principles to protect 6-year-old MR, the child at the heart of this case, from the traumatic loss of his second parent, DebraH. The woman who raised him from birth, he is now 6 years old.
If she's a parent, why do you have to have estoppel?
Because, unfortunately, the lower court, the appellate division, declined to exercise the equitable estoppel doctrine.
I guess what I'm getting at is, aren't there alternative ways to reach the results you're asking for? You can say that she's a parent, or you can say that Janice is stopped from saying she's not a parent. Aren't those different?
Our position is that she is a parent by virtue of the functional parent-child role and bond that formed between them, and that Janice should be stopped from now asserting her right to claim that DebraH is not a parent by virtue of a lack of a biological or adoptive connection.
But if she's a parent, you don't have to stop anybody. You don't have to get to stage 2.
Well, then we could have a ruling in favor of our client's right to continue to have custody and visitation and obligations of financial support.
So you say she is standing under Domestic Relations Law 740 to maintain a proceeding, this custody proceeding that was, this habeas that was brought in Supreme Court.
We're asserting she has standing under Domestic Relations Law 70, but also under the Court's common law equitable powers that have long been held to apply irrespective and independent of.
What about Allison D. in relation to the first claim under DRL 70?
Allison D. Did rule that under DRL 70 the term parent is confined to a biological or adoptive parent. It's time for that to be reconsidered.
Do we have to overrule Allison D.?
You do not have to overrule Allison D. in order for DebraH to have standing to proceed, because the Court does have freestanding.
How can we distinguish Allison D.? How would you distinguish it?
Well, a number of courts have noted that Allison D. is focused on the statutory definition of DRL 70, and that DRL 70 does not preempt the Court's common law powers.
So what, we just didn't reach the issue there? Was that what the argument would be?
Your Honor, it is difficult to determine, based on the short passage in Allison D., whether it was actually reached and ruled foreclosed for a litigant to bring an equitable claim.
Wasn't it raised in the dissent in Allison D.?
It does seem that the dissent addressed, Chief Judge Kaye's dissent addressed her position that there should be equitable powers asserted. So it may be that what the Court would need to do is overrule.
Case. I mean, here we have a civil union in Vermont. We have a domestic partnership in New York City. We have more of an indicia of an intent of the parties to become a family group. Don't we have that here more than we had in Allison D.?
That's quite true. The facts of this case.
Do you say that we should recognize the Vermont Civil Union?
The Vermont Civil Union provides another ground. The Court could recognize it to the extent that it provides parental rights under Vermont law. The Court could give comity to it. But in addition, the Court should certainly take.
If we buy that argument, then everything else is over, right? For this case.
It may well be. And in addition, the civil union in any event, regardless of the amount of comity to which the Court would accord it, is extremely relevant to and another indicia of.
So you don't think we really have to recognize the Vermont Civil Union?
You don't have.
That it's the persuasive nature of it in terms of how it relates to this particular case here in New York?
The Court
is another way to deal with it?
Correct.
Can you elaborate how you would propose that we define a parent when you're not in the biological or adoptive category?
Well, one way is been tried and true in a number of other jurisdictions, and that is to recognize a de facto parent based on standards that a number of other states' courts have applied.
Sorry, go ahead.
Is that going to embrace step-parents, nannies, other people other than in this particular situation?
No, in fact, part of why other states have followed this test is because it does screen out people like nannies, for example, who receive financial compensation.
What about step-parents?
And likely step-parents as well. It might depend on the factual circumstances, but it's someone who...
Isn't your client's position rather close to that of a stepfather in some ways?
No, not our client's position is far stronger than a stepfather's. Ours is the position of a father who is the biological parent who plans for the conception of the child long before the child is born. Okay. That's what happened here.
I guess I see your point, but what's bothering me is do you have a predictable, reliable test? I mean, isn't there a very, very strong public interest in knowing who a kid's parents are? And do you have something that will allow the great majority of children to know who their parents are without 6 years of litigation on the subject?
Well, yes, I think we do, Your Honor. First of all, I think what's most important is to focus on the interests of the individual child and not what the great majority...
But isn't that by itself, when you say it's important to focus on the interests of the individual child, you're really saying we're going to take every child one at a time and say what's in his, let's decide who his parents are or her parents, depending on what his best interests are?
I don't think there'll be a question with regard to the vast majority of children. But MR, this child, this 6-year-old has this...
Isn't there going to be a question with a lot of children unless you have I mean, I could understand saying, as a rule, when two women in a romantic relationship have a child by artificial insemination, they're both parents. But you're not really saying that. You're saying, let's take a look at this kid and see how the bonds are with both parents. Doesn't that raise problems?
Well, first of all, I do think that the rule that when two women choose to have a child and use artificial insemination, the non-biological person is a parent. That is the rule that should be applied.
But isn't that absolutely contrary to what you said a minute ago, which is got to focus on the best interest of the individual child?
No, because that rule, in that circumstance where the couple has determined to use artificial insemination, we already have a statute that would make, if they were a married couple, both a parent, and we also have common law that has recognized, irrespective of that statute, independent of that statute, the importance to the child of respecting intent.
I think you're saying that rule is in the best interests of children generally, but isn't there, it seems to me, isn't there a tension that you're not resolving, almost a contradiction, between a rule that may be in the best interests of most children and a child-by-child look at the best interests? Which one are you asking us to do?
I'm asking you to do both, Your Honor, and I think both
How can you do both at the same time? How can you say there's a nice predictable rule and we're going to look at it one child at a time?
Well, for the vast majority of children, their parentage will be determined by whether their second parent, in addition to one biological parent, is biologically related to them or related to adoption.
What about the not insignificant number of children who are in this child's situation, a same-sex couple, two women, romantically involved, giving birth by artificial insemination? Do we look one kid at a time, or do we say either they're all parents or they're all not?
To be realistic, there may be
You're happy with either way that lets you win the case. Maybe you could win the case either way, but which way is better? Which way should we go?
First of all, there are multiple bases on which parentage could be determined.
Yes.
And that shouldn't mean that there is no basis on which a child like MR
Okay, but what if accepting that for the moment, if you're in our position and you have the problem of picking one, what do you pick?
Well, the Court already has the equitable estoppel doctrine, which already, in the Shondell case, recognized a child who did not have a biological connection to a second parent to have a legal relationship to that man, and the Court was capable of doing that, and the lower courts do it all the time.
So what would a test like the Wisconsin case do in terms of determining whether someone's in loco parentis? Is that a predictable kind of set of criteria that one could use to determine?
Yes, that Wisconsin test adopted in a number of other states does provide a predictable.
But is it a predictable, I think the judge is asking you, do we have to have a real hard and fast rule that says, all right, this is a parent, or can you do it case by case? Could you have a set of criteria, let's say like the one in Wisconsin, that would make a case by case approach make some sense?
Absolutely, and that is the beauty of that Wisconsin approach, which really translates the traditional equitable estoppel principles long applied.
That's what it's doing, right? That really is an estoppel kind of approach.
Exactly, and it translates. Excuse me?
He has to
What's so
explain why it's
predictable about it?
predictable.
Explain why Wisconsin is predictable.
Because it lays out a set of criteria that
Which
are
are?
tailored to meet. The criteria are, first, that there was consent and intent on the part of the biological or adoptive parent. That's a very important criteria because it does.
Okay, just list them because you're out of time.
The second criteria is that the couple have lived together. The third criteria is that the non-biologically related adult have actually functioned as a parent, provided.
That one doesn't sound so predictable to me.
Well, this court already in the Shondell case made determinations about what kinds of facts demonstrate that a person actually is a parent.
Does that factor mean that a child could have a series of additional parents? I mean, regardless of whether it's a gay couple or heterosexual parent, you could have different people that you live with during the time your child is growing up. And could there be successive individuals that claim that they functioned as a co-parent with respect to the child?
Well, I think that would present a very difficult case, clearly not this one. It's conceivable that maybe that could be attempted. However,
you could have someone that lives with the child until they're 1 or 2, and then someone who's with the child for 7, 8 years. And, I mean, people do have different romantic partners.
I don't think that would mean that it establishes a parent-child right as a de facto parent, and this state has always recognized 2, not more.
You would say you can't, under your theory, the child could never have 3 or 4?
No, what I'm saying is it's conceivable that somebody could try to present that case. I don't see that happening, especially
in your case, you
Then
had
step-parents could never make claims under the Wisconsin statute?
not if there's already another second parent. This
Without the consent of that parent, obviously.
correct,
They could
unless
adopt.
Exactly.
Okay,
exactly.
You're going to have.
Can I ask one very short yes/no question? You are saying that your client not only has rights but support responsibilities. She's also a parent within the Family Court Act support requirements.
Absolutely, she wants those obligations.
Okay. Thank you, Counsel. You'll have rebuttal time. Counsel, do you want any rebuttal time?
Yes, Your Honor, I'd like 2 minutes, please.
2 minutes. Go ahead.
I'm Jennifer Collier for the attorney for the child in this case. MR clearly needs a method to secure his relationship with his second parent.
What's
his
the
de facto
method?
parent. What's the method? The test set forth in the Wisconsin case and subsequently adopted by many jurisdictions has proved workable in many jurisdictions for the reasons that Ms. Summer set forth.
You think Allison D., our decision in Allison D. is a workable situation in the aftermath of
I don't,
that
Your Honor.
incident?
I think
Today, is it workable?
I think Allison D. has spawned almost 2 decades of litigation focused on the need for children in MR's position, children of same-sex couples oftentimes, attempting to secure their relationships with their de facto parents, and courts reading Allison D. to be an absolute bar to any kind of a determination of a parent that's not an adoptive parent or a biological parent.
Assume we agree with you and we reverse Allison D. Would you ask for that to be applied retroactively?
It should be applied to cases that are currently being litigated, and it certainly should be, a ruling in this case should be applied to this case. I believe that if the court were to rule here on equitable estoppel grounds, it would be based on the words and conduct of the respondent as well as other factors. And certainly in an equitable estoppel ruling, the ruling should apply to the case before the court.
And we always have inherent equity powers to decide what's in the child's best interest, right?
That's true, Your Honor. And indeed, this court has been exercising its equitable powers in situations
Is that literally
like this.
true? Do we always have equitable powers to decide what's in every child's best interest?
The court has equitable powers.
Isn't there a point at which the parents are supposed to make that decision?
Well, Your Honor, the parent absolutely has a right and an ability to make a decision about what's in the child's best interest. But here, where a parent has fostered and created a parent-child relationship with another person to whom she had a civil union, her interest in controlling who the child associates with needs to be balanced against the child's interest in maintaining
Okay, but I guess
his
what's bothering me is the same question I was asking Ms. Summer. You started from the point we've got to find a way to serve this child's interests. Of course, that's your job. That's and it's very, very important. But is that the right starting point, or should we be trying to find a way that serves the interests of children generally, even though it's going to produce a harsh result in some cases?
I think that a way that serves the interests of children generally should not be a bright-line test like the Allison D test, because it will produce a harsh result.
Isn't there, I mean, tremendous interest? Aren't bright lines good in a way when you're trying to figure out whether how many parents you've got and who they are? I mean, isn't there some truth to the idea that it's for many children it's better to know it's more important to know the answer than what the answer is?
Your Honor, bright lines aren't good if you're on the wrong side of them. And here, we're not trying to figure out how many
No,
parents.
they're always good if you're on the right side of them. But aren't they, don't they have a value, and particularly a value, when you're talking about isn't there an enormous advantage to knowing the minute a child is born who his or her parents are, as opposed to saying, okay, now we'll go to court for as long as it takes and figure it out?
Your Honor, I would submit that when this child was born.
I mean, try answering that question. Isn't there an advantage?
I think that there is an advantage when that's possible, and I would submit that when this child was born, his parents knew who his parents were, and many others knew who his parents were.
Well, do you suggest that we could have are you saying we can't have a bright line test, or are you saying that Allison D puts the bright line in the wrong place?
Allison D certainly puts the bright line in the wrong place.
Have you got a bright line in the right place that you can offer us?
I don't, Your Honor, unfortunately, because I think when someone asserts that a person who they held out as the second parent isn't the second parent, there needs to be a hearing.
Well, let me ask you a question. Let me flip the question that Judge Smith is asking you. What's wrong with, for the sake of argument, the Wisconsin test in terms of making these kinds of decisions?
I think the Wisconsin test is quite effective in terms of making these kinds of
If the Wisconsin test applies, do you have a situation where you've got, let's take in a standard, heterosexual couple where you've got a husband who everybody decides is pretty much no good, and there's a divorce and the mother remarries, that the new father can then come in and say, I fit all four of these, I should be declared the parent here, and that reprobate biological father ought to be thrown out of this whole relationship because as far as you are concerned, Judge, if you look at these four factors, I'm the real father regardless of the fact that there's a biological connection there. Wouldn't that be a logical decision?
If you look at the biological father who's no good, he's still the legal father and the biological father. Whether or not he should have visitation and custody with the children is a determination to be made on a best interest hearing.
Would the same thing apply?
A subsequent father coming in would be a stepfather, and I think that person would be screened out under the Wisconsin test.
So the stepfather and the father then, again, assuming a divorce as Judge Graffio was describing, so instead of every other weekend for the biological father, we'd have Saturdays for the biological father, Sundays for the stepfather, and the kid will be just, shuttled around, or does the judge then say,
I don't think the stepfather can satisfy the test. I don't think the stepfather
The mother says he does.
Well, if the mother's living with the stepfather and they're a family unit, then...
And then they get divorced, I mean, she's going to say, yeah, he was there, he fulfills all of these, and as far as I'm concerned, he's better than the drunk I married the first time. I just worry about...
If the biological father's really a no-good father and disappears, then maybe he's going to be stopped when he comes in and tries to get access to the children after having abandoned the family. Many cases have held that.
My concern there is simply that we're putting an awful lot of pressure on courts to weigh all of these things. And if I could, Judge, just one other question.
Go ahead.
If Deborah's daughter was a minor, would we have cross petitions here conceivably, where now they each have a child of a minor, and one saying, well, if you're going to insist on being the parent of my child, I'm going to insist on being the parent of your child, and we can have two custody hearings and decide who's going to win?
If each of the women is functionally the de facto parent of each other's children, the family splits up, then each of the women should have support obligations and visitation and custody rights.
So the artificial insemination, to you, the artificial insemination is not key, even if this child had been the biological child of a man who's now gone out of the picture, you would have essentially the same case?
I think if this child was the biological child of a man who'd gone out of the picture, you wouldn't have an ability of that man to come in and assert his parental rights after having abandoned the family.
So suppose he's just at the fringes of the picture and you're trying to figure out whether he's out of the picture or in the picture.
Then
that sort of thing does happen, doesn't it?
It does happen, Your Honor. And I'd say in the Shondell case, this court observed that in equitable estoppel determinations, the determinations have to be made on a case-by-case basis.
Yeah, if I could get one more question, we're begging for overtime here. What, if any, role does the presumption of legitimacy play in this whole case?
The presumption of legitimacy under DRL 73?
Or a common law presumption. Take it either way you like.
Well, I would say under DRL 73's presumption of legitimacy would apply to this couple if the couple were married, and so MR is not being treated equally as children of married couples.
What about, well, isn't there, I guess I was getting at something different. Is there a policy in the law that other things being equal, children should have two parents rather than one?
I think that under
and rather than three, that two is sort of a popular number?
2 is a popular number. 2 parents may adopt a child. Under DRL 70, either parent may seek custody.
Okay, good. You'll have your rebuttal.
Thank you, Judge.
Counsel, proceed.
Good afternoon, Your Honors. My name is Sherry Eisenpress. I represent Janice R. on this appeal. What Petitioner is asking this Court to do is to reverse Allison D. Let's start right there.
Is Allison D. workable today?
Yes, I think Allison D. is
tell us
workable.
How. With all these kinds of questions, does that raise up in your mind the idea that, gee, maybe it's not workable, maybe it's time to change it?
Allison, well, if it is time to change it, I believe it's up to the legislature to do that. And in fact, on January 6th, a bill was submitted to the Judiciary Committee for the 3rd time, addressing this very precise issue. And it hasn't yet been vetted through the legislative process. There haven't been comments. Interested parties haven't been heard.
Even if it's unworkable, we should wait for the legislature? That's not a rhetorical question.
Yes, Your Honor. And I don't think it's unworkable, and let me tell you why. In 1991, when Allison D. was decided, there was no way for a same-sex couple to formalize their relationship with their child if they chose to co-parent a child together. When Matter of Jacob and Dana was decided, that changed. And second-parent adoption was available. And so for millions of people... Is that
the key here, that there's no...
I think that's part of the key here.
Second-parent adoption?
I think if we're balancing interests here in this case. And one of the interests is the right, as was just decided by this Court, I think, yesterday in the LMB case. The question is, when do you get to a best interest analysis supplanting the determination of a biological or adoptive parent? And you don't get to that analysis unless there's some standing. And in Matter of Jacob and Dana, the Court set up a mechanism. The Court ruled that the statute permits same-sex parents and unmarried couples to adopt the child. So if two people...
So why can't we interpret the statute here to allow for this situation?
You have interpreted the statute here, and so have 50 other appellate courts over the last 20 years. And the interpretation was that the statute doesn't permit it, and the language of the statute has not changed since Allison D. was decided.
There's 3 things we can do here. We could overrule it, or we could reaffirm it, or we can distinguish it.
Well, I don't think there's any way to distinguish it. And the reason I say that is, in that case, in Allison D., the parties were in a longer relationship. They had clearly decided together, unlike here where Janice started trying to get pregnant and purchased the donor sperm and took all of these steps before she even knew DebraH existed. They clearly planned together. So I think that the facts in Allison D. are far more compelling. What about the
civil union and domestic partnership here? Does that have any weight?
Well, there's a couple of responses I have to that, Judge. The civil union...
Why wouldn't we recognize the civil union from Vermont?
The civil union from Vermont, the Court hasn't yet even recognized out-of-state marriages. It certainly has not recognized out-of-state civil unions.
There were 3 votes to recognize out-of-state marriages in Godfrey. if though, and the other four of us said we don't reach the question. If Judge Separak were to pick up a fourth vote in Godfrey, would that end this case? Would that dispose of this case?
Well, if you recognize civil unions, I would say the answer is still no. And the reason for that is when Janice and Deborah were civil unionized in Vermont, first of all, the law did not provide for recognition of civil unions. But second of all, Janice was 8.5 months pregnant at the time. They did not conceive this child after they had entered into a civil union. They did not conceive this child after they entered into a domestic partnership.
Are you saying that Deborah might have no parental rights even under Vermont law?
That's correct.
Is there any law on that one way or the other as to whether the date of conception rather than date of birth determines that?
In the Miller-Jenkins case, which was decided by the Vermont Supreme Court, the parties conceived the child, which is the case that I think speaks to this issue. The parties conceived the child subsequent to them entering into a civil union. Now, in New York, there's a marriage presumption. So if the parties, let's assume for a moment that we say that Vermont civil unions are going to be treated in New York as a heterosexual marriage would be treated, or as a same-sex marriage would be treated if same-sex marriages were recognized.
Or as a civil union is treated in Vermont.
Or as a civil union is treated in Vermont. And the answer to that question is that the presumption is defeated by the fact it's a biological presumption, first of all, so it's kind of not applicable here, because obviously she's not going to have the biological relationship. But even if we go beyond that, the presumption is that you're pregnant, you become pregnant after the event. And so if you, in Alan Schenkman, in his commentary under the McKinney's statute, under the DRL, I think it's under DRL 73, speaks to the issue of the presumption.
The facts here, I guess, are the parties were living together and romantically involved at the time of conception.
Many people live together, Judge. Many people are romantically involved.
Okay, but I guess what I'm getting at is the sequence of events. The facts are the parties live together, one of them conceives a child, they get a civil union, the child is born. If you're trying to make this come as close as possible to the opposite sex situation or the presumption that would apply in that case, should the non-biological parent not be deemed the parent?
No, he should not in that case. And in fact, the presumption would be rebuttable, and they would be able to show that he's not the biological parent. Again, in this case...
Well, of course, I guess I answered your question. I thought called for she, and you answered with he. Yeah, I see your point about the man. Obviously, it's a question of fact. He's either the parent or he's not.
Right, and it's not a parallel situation.
Mm-hmm.
It's not a parallel because you have a biology question. So you have a presumption that is based on biology that can't possibly be applied here. And so what you need is the bright-line rule that Your Honors were speaking about.
Let me ask you a different question. Switch the facts around here. First, accepting basically your adversary's version of the facts, which I know you dispute. But let's accept them, switch it around, and make Deborah the bad guy. Deborah, the day the child leaves, the day the child is born, Deborah finds a more attractive partner, walks out, says, forget about it, I have no more interest in you or the child. Does Deborah have no obligation to the child?
I think Deborah has no obligation to the child.
Isn't that kind of hard on the kid?
I don't think so, Your Honor. I think that we have to draw a line. I think Your Honor's point that you made earlier is critical here. I think that when people are forming families, which is the most crucial and critical role that people play, that people take on in their lives as parents and as spouses, however that is defined, you need to have some certainty. You need to know. Janice could have said, if the rule was, if there was, the legislation had passed, and the rule was that if you live together for 6 months, which is the rule in some places, but not others, if you live together for 6 months, you are opening yourself up to an equitable estoppel hearing. Janice could have said, I'm moving back into my apartment 1 block away that I maintain. There's no dispute about that fact. She could not move in. They could have signed a document that, there's lots of ways she could have geared her actions to address the law.
Suppose we had a rule that said when 2 women are living together and one of them has a child by artificial insemination, it's either conclusively presumed or strongly presumed that both are the parents. That's a bright line, right?
That is a bright line, and if that was the law Your Honor, if the legislature deemed when it was weighing all the various policy considerations that should be the law, then it should be applied prospectively so that people know that the minute they move in, they are taking on not only the responsibilities of a child, but that they're giving up, and essentially that's what it is, a giving up of rights with respect to determining the best interests of your child and who that child associates with.
Why is it different when you have a husband and wife and you have this situation in the hypothetical that Judge Smith gave you? Why should it be treated differently?
Well, first of all, you don't get married by estoppel. If I say I want to marry you, I'm going to marry you, I promise I'm going to marry you. And then I change my mind. I'm not married to you. I am under no set of circumstances, under no law, under no facts am I married to you.
But no matter how irregular the relationship is, if you have a child together, the father still has a duty to the child.
If the father
is the biological father.
So the circularity of the whole thing.
But what about the estoppel argument? Doesn't the other partner have an obligation to support the child? And why shouldn't that be a part of this? I mean, they just walk away. You bring a child into the world by consent. Together you decide artificially insemination. What is the obligation? No obligation? Gone? You walk away?
I believe that DebraH has no obligation here to MR, nor has she paid. She claims she's paid money and all of that.
You both seem to agree.
But I don't think she has an obligation.
You both seem to agree that you can't separate the two. If she has, you would not try to sue her for child support and say she has no rights of visitation.
Well, we absolutely have never claimed child support here, nor
theoretically.
But what's the answer?
But the answer to the question is that I don't completely agree that they have to go together, and I'll tell you why. Because the Family Court Act specifically provides for the application of equitable estoppel, and it provides for that in the context that arises as follows. The legal parent comes to a court, signs a petition, swears an oath that they consider this person a parent, and they are submitting themselves to the court's jurisdiction, asking for the court's intervention. You can't have it both ways. Once you do that, you can't then argue that that person's not a parent.
You would in the Shondell case, Mark D. has a right to visit the child?
Yes, he does. Yes, he does, because I believe that the mother in that case came to the court and said, I am giving over certain aspects of my rights as a parent, just as you do when you do an adoption. And, in Golbin, a case that was decided in the Third Department, it was a very clear statement. How much clearer could it get that Janice did not determine, either from the beginning, as Janice says, or even if you accept Deborah's facts as true, which we don't, but even if you do, at some point Janice said, I am not allowing you to adopt my child. That is about as clear of a statement of intent as possible.
So there's no right of estoppel anywhere but in family court?
Judge, I don't think there's a lot of places where you can't have estoppel. If I promise my colleague here that I'm going to leave him all my money in his will.
But in this context, it's only in family court.
No, the support statute. In Supreme Court, there's estoppel under the paternity and support statute. There's
Why
estoppel
shouldn't
as
there
well.
be estoppel in this case?
Well, for several reasons. One, because there is no statute, and the statutory construction.
But Supreme Court is a court of original jurisdiction.
Supreme Court is a court of original jurisdiction,
Unlimited.
but that doesn't mean that the court can, in the guise of doing equity, violate a statute. And if there's a statute that's right on point, which is this court has held, DRL 70 is precisely on point, and estoppel doesn't apply.
But there's power beyond DRL 70.
Yes, but this court
Why
considered that
isn't
argument.
this a situation that cries out for it?
This court considered that very argument. Throughout the brief submitted in that case, equitable estoppel was argued. And Judge Kaye addressed equitable estoppel.
But I ask you the same question. Why isn't Allison D. really doesn't work anymore? Why isn't it outdated in terms of situations just like we have here? Is it workable?
If Allison D. is deemed to be not workable, the legislature needs to consider all the competing interests, step-parents, boyfriends, girlfriends. I'm not saying that we stand up here and say no one should take another look at this law. That's not our position.
Yeah, but what about
our position is that
but
at
what
the time
about
that
the court's common law power?
the court has
to go beyond 70 and to look at the best interest of the child?
I don't think
to look at this situation and see whether there's an estoppel? What's wrong with that?
I don't think, because what you're
Why
doing
isn't that
then is
fair?
you're setting up a situation.
Why isn't that fair?
It's completely unfair.
Why?
In my opinion, and in
Tell
the
us
opinion
why.
of many. Because, first of all, you're setting up a situation where I move in with someone, and I have a child.
Yeah.
I don't know, and I can't predict at what moment in time, how many baths that person has to give my child before suddenly they have parental rights.
Yeah, but
I can't make
counsel,
that prediction.
accept the facts that your adversaries are alleging. Under that situation, with the scenario that they're giving, why wasn't this a joint decision?
My client decided she wanted to have a child the day her father died.
And a civil union to boot, and a domestic partnership that expresses intent. Why isn't that a situation that, again, cries out for estoppel, that the court has the power to do?
Because, Your Honor, entering into a domestic partnership in New York City, which I don't believe domestic partnerships are available in every locale throughout the state, but in entering a domestic partnership throughout the city, what's your intent? Well, what rights and obligations does that give you? Now,
What about a civil union, which is more defined?
The civil union.
Why did they go to Vermont to do a civil union?
They did.
Why?
They went to Vermont to visit Deborah H.'s adult daughter, who was in law school up there at the time.
Ms. Eisenpress, I apologize for interrupting that part, but I just want let's assume for a minute that Janice R. Gets into another relationship. We don't know if there is, all right? And now I think the child is about 7.
Yes.
So if that relationship takes flight, I mean, and lasts for 2.5 years or 3 years or 5 years or however long, is that person now a parent of MR?
I would say no. I would say that unless Janice R., which she can do right now, she can permit another person other than Deborah H. to adopt that child. If she chose to do that, she could do it today.
But it
would be her, under Troxel and under all the jurisprudence, it's a parent's right to determine if that's in her child's best interest. Once there's an adoption, it's equal.
But I'm just wondering if we find that Deborah H. is a parent and there's a second relationship or a third relationship, do we run the danger of what I was talking about before, where if all of these relationships for some reason or another divide, where MR is going to find himself in 3 different places over a long weekend or something? I just
Absolutely. We address that in our brief, and not just successive relationships. Step parents, I think, are equally, when we talk about the best interest of the child standard, in New York, many kids are raised by their nanny. Now, a lot of these statutes have an exception for paid caregivers. But if you're talking specifically, if your focus is specifically on the best interest of the child and not the relationship between the parties, then you have to look at all kinds of people that enter in and out of children's lives.
You also have to recognize the fact that non-traditional families are enjoying much more acceptance now. There's societal changes that allow it.
I agree.
So going back to Judge Lippman's question, why shouldn't the law allow this?
I'm not saying, Your Honor, please don't misunderstand me. I'm not saying the law should not allow it. That's never been our position. Our position is that the law, up until now, has not allowed it. And my client made decisions and took action consistent with the law that was set down by this court in Allison D. A Matter of Jacob. And she acted consistent with those, is entitled to have relied on that law. If the law is to change...
I'm sorry, I was going to say one more. And anything we do here obviously will apply to heterosexual couples also, people with successive partners and children along the way. So nothing that we do here is that foreign to our knowledge of definition of family today.
I understand that, but I don't think it's the role of this court to weigh the various policy considerations and come up, particularly in the face of legislation that's pending right now at this very moment in the Judiciary Committee to address this very issue.
I understand your point about having clear rules and letting the legislature write them and letting people know where they are. and obviously some of that only legislative action can fix. But couldn't a large part of the problem be remedied if we essentially gave artificial insemination between two women, in a relationship between two women, give it the same, essentially the same significance that we would give the biological relationship between a man and a woman?
Well, perhaps that's one way to remedy it.
And indeed, the law does give out in opposite sex couples. The law does give artificial insemination almost that same significance.
If the male signs a written consent.
No, there's a case in the Third Department that says, yeah, if he does and also if he doesn't.
I think that case is Laura W.W., and I think that case is wrongly decided under the law as it stands. The statute's very clear. Written consent is required. In addition, Judge, there's a further problem with that. Here, again, my client decided before she met Deborah H. that she was going to try to get pregnant, and she was engaged in an effort to become a single mom. Her father died. She decided she didn't want to wait to be in a relationship. She was inseminated on 24 occasions prior to even meeting Deborah H. She suffered miscarriages.
Counsel, if you accept their version of the facts.
They agree with that fact.
No. But they also give many other facts that seem to go towards that they made a joint decision. They're announced as the parents. They're held to hold themselves out as such. They go together to appointments, and all the other things that they allege. If you accept all of those as true, does that change your view in terms of whether they should have the same rights as, again, a husband and wife with artificial insemination in that same basic circumstance? Why shouldn't they be treated the same if their version of the facts is true? Accept that.
I'll accept
the
it
premise
only
of the
for
question.
purposes of your hypothetical, Judge, because we dispute a lot of them. No, the answer is no. It doesn't change my view. And the reason it doesn't change my view is because...
It would be clear, wouldn't it? It would be clear if we did that.
It wouldn't be clear for my client. It wouldn't have been clear for my client. And
if their facts are true, it would be clear.
No, it wouldn't have been clear because my client, assuming she did all these things, just like in the LMB case, the decision that came down yesterday, the father in that case wrote a relinquishment of his parental rights. And this court held just yesterday that that's insufficient, even though it's clear as day that he said, I don't want to be the father, I'm giving you all the rights. It's clear as day. And counsel, in fact, counsel for Deborah H. argued that that relinquishment is invalid because it didn't comply with the strictures of the law, certainly at the time that he executed them. Now we're going to say that my client writing a couple of Hallmark cards and taking a couple of actions is the equivalent of a formal adoption? I would say if that's the way this law is going, first of all, I think that that's going to spawn...
You're saying that if you're a parent with a Mother's Day card, you've got to be a parent without the Mother's Day card?
I don't follow, Judge.
I see your point, that parenthood shouldn't depend on whether one of the partners sent a Mother's Day card, but can't we make I guess I'm coming back to what I keep saying. Can't we draw the bright line either way? That, I see the problem with making parenthood depend on a Mother's Day card, but could it be the answer to say she was a parent before she sent the card?
Well, you could say she's a parent. Look, in the District of Columbia, they just passed legislation that has nothing to do with the relationship between the adult and the child. It has only to do with the nature of the relationship between the two parties. In some states, there's a dispute as to what the actual number of states are here, but in some states they say if you live together for 6 months. In some states they say a year. In some states they say 2 years. In some states they say you have to have financial commitment.
We're
There's
in
all
New York.
kinds of standards. We're in
Yes,
New York. New York has no fault divorce.
I do see your point, but we're in New York, and we're in a state where same-sex relationships with children, like especially female same-sex relationships with children, have been quite common for a long time now. We're talking about decades. Do we wait forever for the legislature? Isn't there a time when the common law has to adjust?
Your Honor, again, I think that if the common law has to adjust, you'd be reversing Allison D. You'd be changing decades of law that my client relied on. And
But
so, again,
that's the question, Counsel. Does there come a time when we do exactly that?
I think the answer is that the legislature has to act, just as in the case in other situations where one might hope the legislature would act, but that's clearly their role. This is a policy determination.
You keep talking about the reliance interest, that, you know, these people are adults who relied on, made their own decisions and relied on the law as it was. But is it relevant that there's a party in this who's not an adult and who can't have relied on anything and who has to be protected by the state?
And the role of but not by the state, Judge, and that's where I think there's a fundamental flaw here. You don't get to the role of protecting the child. That's Janice's job until
What about the presumption of legitimacy? Doesn't that essentially operate to say, when possible, we're going to get a second parent for this child?
Well, again, the presumption of legitimacy that you're talking about under DRL 73 is, A, it's rebuttable, B, it's based on this biological connection that wouldn't apply here because Janice was pregnant.
But why isn't
when
that a
happened.
good framework for this situation, where it's not biological, but the framework of 73, why shouldn't it be applied in this situation? Wouldn't it draw an appropriate line and deal with the kind of situation we're talking about?
It wouldn't draw an appropriate line in this case for my client,
And
Judge.
who does protect the child? The only one in the world
My client
that
protects
your
the
client
client.
can do anything relating to that
No,
child?
Judge.
And there's
Absolutely
no
not.
ability to protect that child?
Absolutely
Nobody
not true.
protects her. Who protects the child?
If my client
Yeah.
engages in abuse or neglect or abandonment or surrender, there are laws that absolutely allow
But denying the child their parent.
Well, that's a circular question, Judge, because you first are saying she's his parent, and then you're saying she's denying him.
Well, do you
We're
agree,
saying
do you
she's not
agree
his
that the
parent.
state has an obligation to protect the child? And let's say maybe not in this situation because both parties are people of means, but in a situation
Not
where...
anymore.
Well, well, such good advocacy here, I can understand that. But in a situation, for example, a support situation, the next case, where a child could become a public charge, for example, I mean, isn't it better that the state can look to two people who would have the obligation of supporting this child?
Isn't that precisely why why the Family Court Act, Section 418, distinguishes, just like it does in many instances, makes a distinction between support issues and custody and visitation issues. And by the way, let's be clear, DebraH's seeking custody and visitation here, but it makes a distinction. For example, if my colleague and I are married and he doesn't pay child support, we could put him in jail. If he doesn't visit the child, if he deprives the child of an emotional connection, which is what petitioners are arguing treated equally under the law, he can't be put in jail.
But if you
He's free to do that.
if you interfere with his visitation,
Yes, but that's a different question.
then he can withhold his support.
I can't interfere, but he doesn't have to maintain that emotional connection. There's no law. The law, the state has deemed, and maybe that will change, the legislature will change that, and that's okay. But the state to date has deemed, by virtue of the inclusion in Family Court Act 418 of the equitable estoppel provision and not the exclusion, which is specifically acknowledged in the proposed legislation, has deemed that they're going to not interfere.
Your case is in
the
Supreme Court.
Yes.
And we established
The same
earlier that
provision.
Supreme, well, they do have equitable powers. They're not a court of limited jurisdiction.
Yeah, no, I'm
Family
certainly
court.
not questioning the fact that there are equitable powers. I'm just saying that, you can't get married by estoppel. You can't be forced to leave someone your money and your will. By the way, is DebraH now, if God forbid something happened to DebraH 2 days after she's deemed a de facto parent and she died, would her daughter be obligated to share her inheritance with MR?
Maybe.
That's an issue.
That's an issue.
So, thank you.
Thank you, Your Honor.
That's the next case. Okay.
I have a question for you. If we agree with your position so that DebraH is called a parent here, if the biological mother were to establish a relationship with someone else, would that foreclose any adoption?
Yes, it would. Deborah would be a legal parent, and there could be no adoption unless she relinquished her parental rights.
So it's an only two rule that you're proposing?
Yes, indeed, and I think that takes care of a lot of the concern.
And what about your adversary's last question? What I mean does your client now have two distributees if God forbid she passes away?
Yes, she does. She absolutely does. She bears all the burdens as well as the rights and privileges of being a parent. Allison D.
Isn't that another rather good reason for a bright line? I mean, we're going to have a trial in surrogates court as to how the relationship was before we figure out who gets the money?
Well, a good bright line is one that Your Honor has been talking about today, and that is if a couple uses donor insemination, two women, then the same kind of presumption that DRL 73 provides, which, by the way, is an irrebuttable presumption, not a rebuttable presumption, should apply here. The Oregon court...
You think this one should be irrebuttable, too?
Correct. It should be. When two people intend to bring a child into the world by means of anonymous donor...
when you say when two... Can you rebut it by disproving the intent?
Yes. If, in fact, there was no intent. If, in fact, somebody said all along, I am not...
But in your facts, you're saying there isn't
Absolutely.
intent.
Absolutely.
But haven't you undermined the certainty of the rule by saying that it depends on intent? So let's go back to the surrogates court. God forbid your client has passed away. Your adversary's client has had a change of heart and now thinks that she was the mother all along, and she's left a large estate and she wants half of it. And the issue becomes one of intent. We're going to have a trial with one of the parties dead on what the intent was?
You know, that is not the situation because our client has already said...
I know it's not the situation, but if you have the hang-up that I seem to have about bright-line rules, then we have to worry about how they're going to affect other situations. That's why I'm asking.
There might need to be a determination of the facts, but the courts are equipped to do that and have been doing that all for decades, if not centuries, and there have been a number of cases involving anonymous donor insemination where somebody has come in saying, I didn't want my partner, the biological parent, to do that.
Well, isn't that true in almost any area, that any bright line rule is obviously subject to whether the particular circumstance fit the bright line, right?
Absolutely.
I mean, it's not different here than anything else.
That's right. There always is going to have to be a fact showing.
Is there any time frame that we need to consider here? I mean, could someone in a situation comparable to what these two individuals have gone through, could you wait 10 years and then when there's a pending adoption, could you come in and say, no, you can't adopt because I'm actually the parent?
Well, if during that 10-year time...
It seems to me there's got to be some reasonable time factor here. I haven't heard you talk about that.
Okay. If it's a situation in which, if during that 10-year time things have gone smoothly and the non-biological parent has been a parent, there would be no reason for them to necessarily have come into court to get some kind of judicial declaration. If suddenly after 10 years, we have a 10-year-old child in that case, just like we have a 6-year-old child here, says, oops, I've met somebody new and I want them to adopt our child.
So there's no significance, really, if you left if there was no second parent adoption in all those years, that wouldn't matter in terms of when you come in after 10 years?
That's right. If there was a reason...
But what about the support obligation? Would that lapse?
No. The support obligation would always be there.
Are you really saying that you can lose parental rights by abandonment? Is that all there is to it?
Well, I'm not sure what hypothetical I would be responding to, but yeah, abandonment would be the way. Once you make a commitment to parent the child,
okay,
just like
let's say you win this case. DebraH H. is the parent, is determined to be the parent. She remains so until there's the same sort of abandonment that any other parent would lose rights.
Yes.
Even if her interest cools, there's another partner on the scene who's wonderful with the kid. It'd be much in the best interest of the child to get DebraH H. out of the picture and the new partner in. Nothing the law can do about it, or can the law do something about it?
It would be the same as if it were a different sex couple.
In that case, there's nothing the law can do about it, correct?
It would depend if there had been a real abandonment. But
Short of abandonment, there's nothing the law can do.
That's probably correct. Yes, Your Honor.
So the best interest of the child doesn't always win.
And we have a bright line rule there for you. Okay, we treat that it's the same rule that would apply to a different sex couple. And I think the idea that once a couple agree that we're going to have a child by anonymous donor insemination, where by definition there is no second known parent, and there are two people who are committed to make sure that there are two parents, both have to live up to that commitment.
I guess what's bothering me a little bit in your presentation is that something tells me it's in the best interest of the child to have a biological and an adoptive parent, so that there's two readily identifiable legal parents there. So would this discourage people from pursuing adoptions in this kind of situation, because you don't quite know 8, 10, 12 years down the road whether they're going to want to be called a parent or not be called a parent?
I don't believe it should, and I hope it wouldn't, because it's still important for there to be adoptions for a number of reasons to do with...
Why would it be different than a heterosexual couple?
Well, that's true. There would be actually...
People don't necessarily adopt, and sometimes they do, and it depends on the relationships, and it's a complicated, relationships are complicated.
Yeah, let me, if I might just respond, I think this is important. If the same kind of presumption that we have in DRL 73, which makes a person the legal parent, applies, then there would be no need for adoption. That's what the Oregon court said in the Shinovich case involving a different sex couple. We're going to apply the same presumption.
On what basis do we say it here? In other words, let's say that we're ready to do it. On what basis do we do it?
It would be applying the same equitable estoppel and best interest principles.
So it's an equitable estoppel argument, bottom line.
Yes, it would be. And it would be an argument that we recognize that it's crucial that MR and other children like him whose parents are using anonymous donor insemination have a second parent, that we will apply the same principles that apply to a different sex couple.
Okay. If I may offer you one more hypothetical. Almost the only fact, as I can see, the parties agree on, is that your client wanted to adopt and her client objected. I know, yes, with the nature of the conversation, you totally disagree, but those facts are true.
It is
I'll rephrase it. Your client wanted to adopt and her client said no.
Her client said yes.
Said yes.
And said yes.
Okay, go ahead.
And then our client said, great, then let's continue in our relationship. You move in with me. We will have a civil union.
I'm talking about it. There did come a point. You're going to tell me a long story, but the end of the story is your client says, no, let's adopt, and the other one says, no, no.
Only after my client
only
relied on her
after,
promise
but
that she would.
we skip the only after because your red light is on. That did eventually happen.
It did
now,
eventually.
I want to reverse those facts. Suppose her client had wanted your client to adopt, and your client said, no, thanks, I'm not interested in adoption. She still have the same rights she's claiming today?
Yes, and she'd have the same obligations.
Obligations I have no problem with. Why shouldn't, when she's in that situation, when she says, I don't want to adopt, why shouldn't we stick her with the obligations and deny her the rights?
If the child still needs her to continue to be his mother, and that's ultimately...
Even if she's unwilling to adopt him. We're supposed to... this is a woman by hypothesis unwilling to adopt this child, but she still has a right to visit, to claim custody and visitation?
I know that bright lines are very appealing, and you'd like me to give you one right there, but that might then go to the intent of the parties. Did she, in fact, hold herself out as a parent and function as one?
Okay, thank you. Counsel, rebuttal. 2 minutes. Go ahead.
Okay. Well, we're talking a lot here. Judge Smith was talking a lot about a bright line if it's a heterosexual couple, right? The father is either the father or he isn't. But just as a reminder, in cases where visitation and custody has been awarded through equitable estoppel principles, the couples have been heterosexual couples where the husband is not the biological father. The Jean Mabie H. case from the Second Department, the Gilbert A. case.
Aren't those kind of idiosyncratic facts? And aren't the facts here almost prototypical facts? I mean, you're going to get this kind of case. You don't get Chandel every day. But you're
You
going
don't
to get this
Shondell
case
every day. You maybe get Jean, maybe H a little bit more often than you get Shondell, but certainly here, this kind of case has come up over and over and over again since Allison D., and children have been unable to secure the
Well, okay, but
the second
doesn't that
parent
suggest that it's a
relationship.
bad idea to examine every one of them one at a time?
Well, no, Your Honor. Well, Allison D. actually encourages the problem of examining them one at a time, because you can have a situation where there's a civil union, where there's an agreement to parent, where parenting goes on for 4.5 years, and then someone says, oh, well, look at Allison D., I can deny all that, and then we have to have a fact
Well, Allison D., your position is Allison D. shouldn't be applied in a simplistic way that irrespective of the well-being of the child.
That's right, Your Honor. And I think the existence of Allison D. has encouraged behavior and spawned litigation like this case and the many, many cases that Respondent referred to.
So you think life would be simpler if we overturned Allison D., essentially?
I think people would be, yes. I think that it wouldn't encourage the kind of behavior that we've seen in this case, that is alleged to have happened in this case.
Okay. Thank you, Counsel. Thank you all.
Thank you, Judge.